Okay, we are recording. Welcome to a meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. I can begin by taking roll, although I know that Amos Hartston is running a few minutes late. But Kirkmeyer? Kim?
Here.
Okay, and Sarush?
Here.
Okay. And we have at least one member of the public who has a hand raised. Oh, Stephen Fleischman. So do we want to go ahead and start? Oh, there's a couple of people with hands raised. So do you want to set a time limit for the comment?
Yeah, we don't have a chair of this.
Okay, so I'm going to set a 3-minute limit.
Yeah.
Okay, great. All right. Stephen.
Hey everyone, long time no see. Look, real quick, number one, I sent the memo. I just wanted to say if anyone has questions for me about the memo, I'm happy to answer it.
So Stephen, this is Ioana Petru speaking. Did you see Greg's responses to your memo?
No, I didn't.
Oh,
Okay, so
Stephen, I'll send it to you now.
yeah, it was sent out earlier this morning, and there was also, Greg just sent out very recently a comparison, which, as he noted, was nice in the sense that there was quite a bit of agreement actually. But I thought, Stephen, first of all, thank you for putting that together. Between that and Greg's responses, I thought it was very helpful.
Okay. Number two, I spoke with Carolyn Shining yesterday, and she reminded me that we voted against regulating the amount of fees. And so given that, I would withdraw my comment about 25% versus 33% for contingency fees. And in fact, I think to be consistent, the group would have to drop any limit on contingency fees, given that we decided not to regulate fees. And then my third point, which may or may not be moot in light of Greg's email, is I just wanted to reiterate my opposition to fee sharing and paraprofessional ownership in law firms. I just got a long email from Greg. I would need some time to sit down and read through it. Justice Petro, I right here, I'm just a member of the public. If you want to cut me off, you can. If you want me to read this and give responses, I can.
Yeah, here's what I suggest. You are a member of the working group. I'm going to ask Linda to move you into the participants, but I am going to ask for you to hold in regards to any further comment at this time, and to please, if you could, review Greg's responses. I think you both have given this a lot of thought and consideration, and so just like I'm hoping that everyone reads your comments in advance, it'd be great if you read Greg's.
I will do that right now.
Thank you.
Thank you.
Did we not specifically leave out contingency fees from the fee cap vote?
Yes, we did. Linda.
We did, but I'd like to, before we have any further discussion, hear from anyone from a member of the public who would like to make any comment. I note that Ira is also in the attendees, and again, as a working group member, I think it's easier if you just move him into the panelists. But right now I see that Angela, who, thank you for joining us again, is with us as attendees, and I'd like to hear from her.
Thank you so much. I also would have liked to see the response to the memo. I read Fleischman's memo, and I had prepared a little bit of comment in terms of the fee sharing, and I don't know if it's a moot issue or where it is, but I'll go ahead and state it. One of the reasons why I think paraprofessionals should be entitled to fee sharing is because, as opposed to, as he raised the issue, where certified paralegals are not and law clerks are not, is because they have to provide services under the supervision of an attorney and not directly to the public for compensation, with or without that supervising licensee. So whereas the paraprofessional can, and so that to me that would be the one of the differences. I'd also I read the different draft informed consent and written agreement rules. So in a practical sense, as an LDA that provides written and oral notices to the consumer on an hourly basis, the more concise information, the better. I really liked, and forgive me, Church Myers consolidated and Sharush's consolidated notices, because honestly, what I find is the consumer will glaze over and just stop listening. So I think we should think about the disclosure like we think about our declarations, right? Every line is precious real estate. So the consumer hears and sees the information, but they tune out and then they stop listening. And then later down the road, they ask me for legal advice and whatnot. I'm like, well, we talked about this in length, da, 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 da. And so I would also like to remind that, if we go back to the Justice Gap study, the biggest, one of the key issues is the lack in knowledge for the consumer. And so, I mean, we have to spoon feed them in increments. And just to go back, is just the more concise, consolidated, the better. And thank you so much. And thank you for all your work.
I don't see anyone else with a raised hand, so.
I don't either. So who's leading the discussion today?
Right, Greg, I think you're gonna kick us off.
There we go. Okay, well, let me, I will share my screen and we'll just look at the work plan for today, and then we can get right into what we want to talk about. That's 3. Okay, can you all see the work plan for today? Okay, so I wanted to just kick off again with any comments on the rule revisions that I forwarded around, and I think were posted on the State Bar's website, reflecting any of the decisions we made in the last meeting. And if anyone has any comments on that, or if I didn't capture the subcommittee's decisions accurately, just let me know. And that would, I think, principally we talked about last time, Rule 5.4. I think we touched on Rule 1.13, but I don't believe there were any changes to that rule. And there were some other ones that I can't recall right now. I think 3.3 as well, about ex parte hearings. Seems like there's no comments on that. So what we're going to do today is that we're going to take up, of course, the mandatory disclosures, informed consent, and written agreement. Thank you to all the subcommittee members for forwarding your rules. We will probably spend about hopefully 40 minutes on that and see if we can come to some consensus on how we want to deal with these rules. Next, I want to return to Rule 1.5. We had reserved this issue of the contingency fee cap. Fariba had said she wanted to revisit the 33 1/3% cap that Kim and Amos had come to consensus on. And then I want to take up 3 new rules that we haven't discussed yet since the last full working group meeting. One is Rule 5.3.1, and I will discuss what the purpose of that rule is, and then also we'll review Professor Moore's comments that he provided. Then I want to take up Rule 3.6. Steve Fleshman provided some feedback at the last working group meeting that he believes that we do need a version of this rule for paraprofessionals, especially in the context of family law, if they're going to be handling high publicity divorces and whatnot. And then Randy made some suggested additions to the rule for Rule 1.8.1 regarding sexual relations with current clients to try to fill in a gap that exists. So that is, for lawyers, that topic is regulated both by the rules of professional conduct and by a provision of the State Bar Act. And his suggestions really try to bring in some of the provisions of the State Bar Act into the rule itself, and we can discuss that as well. All right, so what I did, as a subcommittee members know, I tried to, because it was making my head spin a little bit, trying to look at everyone's different versions of the rule. I tried to put together one comparison sheet looking at all the 3 different versions of the rules that you each provided. one, to just organize my thinking, and also to really understand where is there already consensus on different aspects of these rules, and hopefully it can organize our discussion. So what I discovered was that there is a lot of consensus when it comes to the mandatory disclosure, or as I think Amos has rephrased it, the notice to consumer rule, and the written agreement rule. And the big divide seems to continue to be around informed consent and where that makes sense, whether it should be incorporated within the written agreement or whether it should be a separate writing. So what I would suggest is that we start with the mandatory disclosure rules and walk through the different versions that each of you provided, and notice where there's already consensus on different aspects of the rule, and where there may be some disagreement, and then move through that and see if we can come to some consensus on that particular rule, then move on to the written agreement rule, and then finally circle back on informed consent. Does that make sense to everyone? Okay.
I actually have a concern with that. I can voice it. We can still move that way if everyone thinks that's most efficient, but I don't want to restate what I've stated several times in the past. But my concern is that the new edition of this initial disclosures, notice to consumers, really undermines what we've sort of discussed and agreed on in the past. The reason why I am less strict about needing this to be in writing is because I think there absolutely needs to be a written informed consent. So if there's not going to be a written informed consent, I think my views about what needs to be disclosed, right up front is going to significantly change, including that it needs to be in writing and much more detailed. But my view is because there's, because of course the consumer needs to be provided information to make an informed choice, and that can't be done right up front. I don't want to make it too burdensome to have 3 different requirements. So I'm really concerned about putting this up front and leading the discussions, because I think that really changes the dynamics. I would much rather focus on where there's disagreement about the informed consent and have that, and that changes, I think, what we do with the other rules.
Okay. Does anyone else have any comment on that?
This is Kim. I think for me, I agree that there should be something written in the second step. Mine is that I do think it doesn't make sense to me to have 2 different documents, although I understand the importance of pointing it out. But I do agree that there should be something written, Amos. So that from my perspective, that second step, I do think there should be some written agreement that they're acknowledging all of the issues. It's just, for me, I think it should be included in that written agreement, because I went and looked at the names, and one is like informed written consent to representation, and one's written agreement to representation. And I know the whole informed consent discussion, but I do think there should be something in writing in that second step, whether the title is, I think, kind of where we're getting stuck.
And for me, I don't mind that the notice to consumers, and I like that title, to be written as well. But my experience with litigants says that they do not read in detail what we want them to know. That's why I'm added that the paraprofessional needs to inform them orally within the first few minutes of conversation. And you just heard Ms. Grahava also talk about the need to be concise, to consolidate, because people don't read. And I say that from firsthand experience in my work with self-represented litigants. Okay. And whatever you decide, however you decide to organize today's discussion, I'm fine with that.
And I'll make 2 observations. One, I hear you, Amos. My only issue with the way that we've been approaching this is we really have been focusing quite a bit on where everyone disagrees rather than where we agree. And we do need to put something forward to the full working group. To the extent I think you disagree with the consensus that maybe Kim and Fariba come to, I think we can provide alternatives to the working group when it comes to these rules as well. And let the full working group decide, and each person can make the case. But in the interest of moving things forward, I think it's really important for us to find where we agree with one another. That's one thing. The other point, well, I think that's just the point that I would make right now.
I'm fine. So I'm fine understanding that my views about the initial notice to consumers assumes there's going to be a written informed consent. I'm fine proceeding that way.
And I think what Kim, if I can underscore what Kim said, she agrees, and I think Fariba also agrees that there should be a written informed consent. I think where the difference is whether or not it should be a separate writing from the written agreement. Okay, so going through the mandatory disclosures, what I try to do is group the different elements of the versions of the rules that you had. The type of disclosure, whether it's written or oral or perhaps both. Fariba just mentioned that could be both as well. What the triggering event is, when is the obligation become ripe for the paraprofessional? When are they obligated to discharge this duty? And then the required elements. And if we can just walk through those quickly, because I think seems to be some consensus in a lot of these different areas. Now, both Fariba and Amos, you use the term in simple language. There's no longer a written agreement, a written requirement under your versions of the rule. Whereas Kim, I think includes both disclose orally and provide written disclosures to the prospective client in their preferred language. She has that in paragraph A. And in paragraph B, the disclosure required under A shall be signed by the licensed paraprofessional and the prospective client, and shall be obtained whether the licensed paraprofessional client relationship subsequently ensues, and that it should be a separate writing from the written agreement. So those are the two options that you've provided. I don't know if you want to discuss.
May I just address language access for just a moment?
Mm-hmm.
I'm all for language access, absolutely. I'm just thinking, if a Farsi speaking person walks into the office, or Spanish versus Spanish speaking, which is more common, how can they have? Are they supposed to have a Farsi speaking or Farsi or the notice printed in Farsi and all of the exotic? I'll call them exotic languages because they don't come up as often as Spanish and Vietnamese, of course, depending on the county you're in. I'm just wondering, when we say in their preferred language, is that too onerous of a requirement that we're placing on them?
Well, go ahead.
It might be, but how do you protect the public if they don't get it in the correct language? So maybe if we leave it to, I'm okay going to the language only and not having a written disclosure, but there has to be, either they use a language line or they use some form of getting that to the individual in their own language. I think they have to understand it in their language, or they have an interpreter there, or
to me, it begs the question, if you can't provide it in a preferred language because you don't speak the preferred language, then how are you able to provide the disclosures in the first place? And how are you able to represent them in an effective way?
I'm just pointing out, having the document already available in their preferred language, it's just not possible. But having access to language, oral translation versus having a written translated document, that's the difference. You see what I mean? So,
and we had discussed having the state bar actually provide these types of notice to consumer disclosures in a form. We do provide, I think, other standard forms to lawyers when they are required to obtain acknowledgement of certain disclosures, like mandatory fee arbitration, in multiple languages. I don't know the number of languages, but
I'm wondering if we should set that one aside and go to this, like the required elements or the triggering, just because it's a little bit more of form rather than content. And what I would say, in line with what you said, Greg, to the extent that it is a standardized disclosure, the state bar could provide, I think there are 6 languages that the state court systems now, provide documents in, so the state bar could at least do those 6. And I know we've done that with the complaint online attorney complaints. You now have access to it in 6 languages. So I think there's a way we could try to address the language access issue to the extent this is standardized.
Mm-hmm.
And could I just go back? I'm okay, because we know that later on we're going to have an actual written agreement. I'm okay going with Fariba and Amos's writing the way they wrote it, that it would be only in a written document basically to them, or you're giving it to them orally.
But I do just want to make clear, again, sorry to repeat myself, that the reason why is because the types of disclosures or the required elements, I think that are standardized at the very beginning of the discussion is not the information that's needed to make an informed choice. It's sort of initial information that they're not a lawyer. So I think it might depend, Kim, on what information is in here, because this is just sort of a standardized form that is explained. That's very different than saying, I can help you with this part of your case, but I can't help you with that part of the case.
Right.
Okay. Well, I think, should we move to the required elements then and circle back? I think the triggering event, it seems that everyone's in agreement that it's, to the extent we're going to have this type of mandatory disclosure or notice to consumer, that it be prior to proceeding with a consultation. I know, Fariba, you added also within the first 3 minutes of the first conversation that these disclosures need to be made.
Yeah, I picked that up from the private child support enforcement legislation. I thought that was really important. Then from previous conversations that we've had in this committee, I remember some concerns, especially raised by Amos before Kimberly joined us, and I agree with that. That if these notices are not given until the client is ready to sign, at that point the client may have already shared too much, and Amos, I'm hoping that I'm remembering your concern accurately, may have shared too much, they're put in a position where they're going to sign anyway because they've come too far in this sort of professional relationship to back out now, versus if it's provided at the very outset, then the client now is going forward with the consultation, having that information, and they may make a more informed and better decision. And I think that may be the reason it is also in the private child support enforcement legislation. I should have gone back and looked at immigration consultant legislation to see if they had something similar. I just thought it's really useful to put that in there and require that disclosure to be in the front. I really agree with that.
Can I ask what people think the flow of the engagement is going to be? So like I've hired lawyers a couple of times, and I had one conversation and I, signed an agreement. So like, I feel like we're contemplating, like, you're going to come and you're going to talk and have your initial disclosure. Then you're going to set another appointment and come back. We're going to have another conversation where you're going to tell me a little bit more about what you want me to do. And then like, how are we imagining this engagement process unfolds? Like multiple conversations before you decide? Or is it all one conversation? We start with oral disclosure, then we go, how does it work?
So I'll just give my impression of how this discussion went. So before we added this third one, which is this notice to consumers up front, I think we just had 2 separate things. One is a written agreement, tracking what attorneys have to do. These are the terms of our engagement. And a separate writing that was making sure that the consumer understood the limitations of the license and the risks and alternatives. And those could be done at the same time. It could be done first. It would be better if the informed consent happened first because of what Fariba just mentioned. There, might be too late at a certain point after discussions, but there's no requirement that it had to be done before discussions, just had to be done before representation. I think the addition of an initial notice was contemplated. And again, it wasn't my suggestion, but I think that whoever suggested it was thinking there might be something that could be earlier. It might be more important to do something earlier, even before the discussion happened. Contemplating that it could all happen at the same time, but in cases where it doesn't, it might be better to get some initial information to the consumer.
I'm envisioning, it could certainly take any form depending on the, client and the situation, but it could also happen in one shot. The client calls, the paraprofessional gives the notice and say, how can I help you? And they have this discussion, I'll call you back, or whatever happens. I think it could really happen anyway. And I know we have Elizabeth here who actually handles clients. And I'm just curious. I don't want to put you on the spot, Elizabeth, but maybe she can share.
Okay.
Yeah, sorry.
Could we, I think, because I just don't want to sidetrack the conversation. I think I really would like to go through the required elements, because I think it might help us. If we have consensus on the required elements, it will help us decide whether or not this is something that can be provided and an acknowledgement be obtained without knowing anything about the client. I mean, is it truly a notice to consumer, or is it starting to fade into a informed consent? So if we go through the elements, I think that's helpful. I don't know if we start rule writing based on the way we envision the flow, because there's going to be so many different factual scenarios that this rule is going to have to adapt to. So I don't think that's probably the best way to approach rule writing. I think we want to have a rule that's going to apply to all scenarios. Does that make sense?
Yes, sorry.
Okay. That's okay. So the first item everyone agrees with, the licensed paraprofessional has to say that they're not a lawyer and they don't need to know anything about the client to provide that information. And everyone agrees with that one. The second one, scope of license, a disclosure regarding scope of license. Again, I don't think they need to know anything about the client other than that they're coming to them, because this really has more to do with the paraprofessional's license and what they are authorized to do and what they're not authorized to do. Fariba has one variation on this, and Kim has another. I don't know if everyone agrees that, one, this should be an element of a notice to consumers, and two, if they have a preference for the way it's phrased.
So I also had one. I think you might have.
Okay, let's see. I might have just not put your name next to it because it may have been similar to me.
As I read it, there are two differences. Has a license to provide limited legal services, and then second line, cannot provide all services that a lawyer performs in this area. Those are the two differences I spotted.
Yeah, I saw those too.
Yeah. So I'm sorry, Amos, that you should be attributed to this one as well, because you subscribe to that one.
Amos is a little different though.
Yeah, I think it's a material difference. So I think Kim suggested that they need to disclose that they can't provide services outside of their practice area. And I think for me, the important disclosure is they can't provide all the same services that an attorney can provide in their practice area.
Okay, let me just copy and paste yours in. Are you all seeing my comparison sheet right now?
Yeah.
Okay.
And I can explain I actually like the language. I know what, Amos, you're right. They're two very different things. I like the language of Fariba's in the first one to say that they can't provide services outside their area. I'm good with her changes that she made on mine. But then the next statement where you're talking about they can't provide full services, that to me fit more into the next one, that you may need a lawyer because I can't do all of the services. So that's why I was okay with Fariba's on the first one and then making the second one very clear that I can't perform the full scope. You might have to go to an attorney.
I think Amos's statement, if we put it in the scope of license, then we may not even need a separate paragraph on needing a lawyer. I just, again, with the goal of keeping it simple. Saying I cannot perform everything a lawyer can do, does that kind of communicate that message? That's a concern.
Or you could combine them and say paraprofessional cannot provide all services that a lawyer performs in this area. And the client may need to hire a lawyer or another paraprofessional if the legal services go beyond their license.
Or just leave it at that, the client may need to hire a lawyer, because you already said I cannot provide all services that a lawyer can. That would be good. I would be okay with that. One paragraph.
Yeah, you could say that or they may also need to hire another paraprofessional who has a different type of license. So, although it's
Yeah,
probably
but just this is on me trying to keep it simple for an initial form or an initial disclosure. I suspect the issue, I think you're technically right, but I suspect the real disclosure issue is that for your case in this practice area, I can't do everything a lawyer can do. I think it's technically true that I don't practice all other areas of law. So if you have other legal issues, I can't help on those either. But I think the important disclosure right off the bat is that I'm not a lawyer. And what that means to you is I can't do everything a lawyer would be able to do in your case that you're coming to me for.
So if we were to combine, would everyone be fine if we combined this statement into Amos's? So it would be paraprofessional has a license to provide limited legal services, the area of practice, the statement that the paraprofessional cannot provide services outside their area of practice, and the paraprofessional cannot provide all the services that a lawyer performs in this area.
That works. I mean, not that I'm a member of the subcommittee, but that makes sense to me.
And you might even just get rid of in this area because a paraprofessional cannot perform all the services that a lawyer performs, period.
I think personally, I think it needs to be simplified and clear.
Okay.
And the purpose of the disclosure is to explain why it's important that they're explaining they're not a lawyer. What does that mean? For us, we all know what it means to not be a lawyer, but that disclosure isn't meaningful to everyone. And the reason why it's important is because I can't do everything an attorney can do in your case. I think the more we water that down or make extra clauses or add in things that are true, and from a lawyer's perspective, we want to include everything, but I think that's the important disclosure right up front.
So if I understand what you're saying, you like to keep it the way you wrote it.
I'm explaining why mine is different from Kim's and Fariba's and why mine is simple and focused on that they can't do everything that a lawyer can do in this practice area. And obviously if I don't mind additional disclosures, but I think the point of these initial notice is to get the message of why it's important they're not, why they're giving, what it means to the prospective client that they're not a lawyer.
Kim and Fariba, do you agree with Amos's version of this provision?
I agree, but I don't think it's clear enough to know that for some people they may like, well, what does that mean? And in some instances, they can do everything that a lawyer can for that case. The problem is when they get outside or they go beyond what that individual can do. So I still think there needs to be something that, because people need to understand, well, what does that mean? That means I may have to get an attorney later on if it goes beyond that. So, I mean, I'm okay with what Amos says, but I do think you need to break it down a little bit for an individual as well.
I see what you're saying. This statement that I have highlighted isn't necessarily always true.
Right. It's not always true.
Right.
It is always true.
Because they can't do jury trials. Is that why, Amos?
Well, again, I think we're just wordsmithing. Let's just take a step back. What does the disclosure that we think is so important that they're not, that they're a licensed paraprofessional is not a lawyer? We know what that means, but what do you think a consumer would understand that to mean? And why is that important to let them know? It's because it's a limited license and they can't do everything that a lawyer can do in their case, whatever the case. Now, certainly it might settle with the paraprofessional doing nothing at all, but assuming the case goes full, There are limitations in each practice area of things that attorneys can do that paraprofessionals cannot. And this is a standardized initial disclosure. So the
What
point
are
is,
the limitations in collateral criminal on a paraprofessional that a lawyer can do that they can't do?
I don't know, I haven't seen the paraprofessional collateral criminal recommendations.
I think
So,
it depends
so
on.
we've been focused on family law, on housing, and on consumer debt. If there is going to be something you can do, then yeah, maybe they don't need disclosure. So this can be just be for all the practice areas we've been focused on.
Mhm. I think it depends on how wide our focus is. That is, if we're talking about, I'm licensed to practice family law, then it's true that they cannot do everything a lawyer can do because of those specific exclusions, right? But if we look at family law, they're there to get help with modification of child support, then they can do everything a lawyer can do.
100% agree. And that's why this is different than the later informed consent, because I think that needs to be clear. And that can't be done in a standardized form before the licensed paraprofessional talks with.
Right. We'll talk about informed consent later, but what we want to make a statement that is going to be true in all instances here.
Right. And I think
So-
that means a wider look, like a wider lens, right?
Yeah.
So again, rather than wordsmithing it, let's take a step back. What does it mean? What are we trying to communicate when we're requiring a disclosure up front that the licensed paraprofessional is not a lawyer?
Well, if I can step in, I think what we're trying to communicate is you have a limited license. There's only certain things you can do, and there may be instances in which you have to hire a lawyer to continue with your matter.
Meaning that they can't do everything a lawyer can do. We just need to simplify it. I think that's all correct.
How about we
but I
just
think we
put a
need to simplify.
period after performs in Amos's thing, in Amos's statement, just put a period after performs. You can't do everything that a lawyer can do, which is
Well, even say it, can do instead of performs. Again, simplification, yeah?
That a
Cannot do-
lawyer can.
Cannot do everything a lawyer can do. It's
you
not.
could, you could recommend that the State Bar take the disclosure form, all of the client-facing forms to, like, there's the plain language.
Right.
Yeah.
I was just gonna say.
Yeah, unfortunately, I mean, we are in the wordsmithing phase right now. We do need to actually wordsmith these things as best we can. And I agree, we need to make it as simple and clear as possible.
I'm okay with what you have right there, Greg.
Okay. Fariba, are you okay with this? Okay, Amos?
Yes.
Okay. And then this next one, so I'm going to just highlight it so we know we've come to consensus on this. This next need for a lawyer obviously is related to this. Kim included it in her version, but I don't believe Amos and Fariba did, or they removed it from the version that was circulated. That they may need to hire a lawyer or another licensed paraprofessional of legal services that the prospective client seeks are beyond the limited scope of legal practice under their license.
So I'll just agree, this is a critical disclosure. I just think it isn't in the initial standardized form. It's when they talk to the prospective client, understand what the matter is, and then they explain what they can do and what they can't do. So
Why wouldn't this be true in all circumstances?
I think this goes back to me to that statement that, you know, there might be something that goes beyond in almost everything with the exception of a few of them. And so the reason I put it up there is because if I go to someone and I know, hey, I'm going to have to hire someone else anyway, so why should I do it at this point? I don't want to tell my whole story to, you know, this paraprofessional potentially, and I'm going to go seek an attorney. I'm not going to do that. Or it's something easy and I can go to this paraprofessional. Chances are it's not going to go there. So that's why I thought it was important upfront to me.
So, and I'll just say, I agree, as long as that doesn't undermine the informed consent requirement, because once they know the information and before they enter into an engagement, I think that's where the real disclosure has to happen. This is sort of a standardized form. So I don't mind including it up front either.
Okay.
I wonder why it's not this under scope of license. Didn't we just say that up above?
These are my made up categories just for this discussion.
No, but
Don't pay attention to the things that are underlined.
no, don't worry about it. But I'm just saying, isn't it repeating what we just said?
Well, to me, it's a little bit different because it's here you're basically laying out the truth of the situation. All
Okay.
right. I have a limited license. I can't provide everything. What does that mean? Well, what that means is you may have to hire a lawyer. If this tells you the resulting risk of these facts. You're coming to me. I have a limited license. I can't do everything a lawyer can do. What does that mean for you? Well, it means you may have to hire a lawyer if what you need goes beyond the scope of my license. And that is true, and because it's may need, it's true in every circumstances, in my mind at least.
So how can we simplify that a little? So you may have to hire a lawyer. It's just, I don't know, just too much. I think just looking at it from a litigant's perspective, it may be too much to take in. So if we can simplify that.
So the license, why did you just say license?
But just to be clear, I agree with Kim for including that.
Okay. We will work on simplifying it too, because I think as Leah mentioned, and I'll mention again, when we really start getting into these rules is going to be at the end of this entire process. So I think what we really want to capture here is the policy decision, whether or not we want to make this type of disclosure. Okay, let's move on to alternative.
Could I make one small point?
Sure.
There is, in one respect, there is always going to be a potential need to hire an attorney, and that relates to an appeal. We decided early on all the services the paraprofessional will provide will be limited to trial courts, not appellate courts. And so there's always going to be that need. I just wanted to remind this committee of that decision we made early on. I haven't seen any drafting or anything relating to that. Maybe we've already decided it and we don't need anything. I just wanted to remind everybody about that.
Good point.
In that connection, I'd like to, Steve's right, of course. We seem to be thinking in this discussion of lawsuits, of things that happen in a court, but some of the things that our paraprofessionals can do are not that. So let's keep that in mind.
Mm-hmm.
For instance, lien clearing.
Mm-hmm.
And also, I don't think there might be a chance for an appeal in what do you call it, limited criminal, but I don't know about that.
Okay. Do the subcommittee members want to address Steve's comment here in this disclosure requirement regarding appeals?
So again, I think that might come in later if there's an appeal at issue with a disclosure, but not the upfront notice that's standardized for everyone. I don't think they need to be talking about appeals.
Okay. Let's move on to the alternative choices element. So I think for Reba, you have provided this language as a required disclosure that there may be alternative choices available to the prospective client, including but not limited to free consultation with a lawyer, limited scope services from a lawyer, free services from a self-help center or family law facilitator's office, or potentially free legal services from local legal aid organization if the prospective client qualifies. Kim's is a bit shorter, but essentially, oh wait,
I think
no.
that's the wrong one, Greg.
Yeah, that's
that
in the
you
wrong
added.
one.
And
Yeah,
I think mine was 3, but edited on the one I had.
Oh,
seen
that's
in
right.
there.
That's right.
So
I'm
it was
sorry about that.
okay. I think my question was to Amos, because Amos pulled it out, and I think maybe now I understand more because you were thinking more in the informed consent and not here. Amos, is that, I want to speak for you, but maybe that's it.
Yeah, no, absolutely. So alternatives are a critical disclosure. I absolutely think it needs to be included. It just, I don't know that it needs to be in the first 3 minutes of their conversation in a standardized form.
And I think if I can try to interpret what your version of the rules, Amos, I think in your informed consent, you want this alternative choices to be more tailored based on where the client is residing, or where the paraprofessional is providing services, what available choices are there, providing specific information rather than what this is, which is just a statement that there may be other choices and maybe you should think about them before you proceed with a
Exactly. If somebody comes in Los Angeles with an eviction case, that might qualify for free legal services from a provider, they need to be told of that alternative. And that can't be done necessarily in a standardized form or in simple language in the first 3 minutes. So that's exactly right. It needs to be more tailored to allow a consumer to make an informed decision. And I don't think it belongs here. But I have no objection of extra disclosures. I just don't know that it's useful if it's not tailored.
And again, my reasoning to put it in here where it made sense is because at this point, maybe I should go seek that before I waste any more time going to this individual, because I wasn't aware that I had free legal services. I can tell you a lot of people don't know that. So that's why I wanted it here. So.
And to be
that's
clear,
been identified in the Justice Gap study. There's a large information gap for a lot of individuals out there.
and just to be clear, I don't mind it. So I would go along with that as long as that
Okay.
doesn't mean we're going to take it out, not have an informed consent requirement, or not in more detail provide information about risks and alternatives.
And I agree with what Kimberly just said. It's not as onerous as what Amos has in mind later on.
Okay. Let's move on to then, again, this is the initial disclosure, the notice to consumer about fees. Fariba had suggested that we include language, general description of the paraprofessional's fee structure and billing methods, and that fees are set by the paraprofessional, not by the state. And Kim's was a price list / cost sheet that identifies the billing method and costs that could be charged. And again, I don't think this is something that the paraprofessional needs to know anything about the client about before they provide this type of disclosure.
Mm-hmm. I took the last part of that sentence from, again, the private child support provider legislation, child support collector legislation. I think that's really helpful to know that this is a private enterprise, and especially now that we don't have fee caps, this paraprofessional is a competitive rate. The paraprofessional is setting their own rate. I think, Amos, you moved this on to your informed consent, if I'm not mistaken.
Yeah, certainly disclosures of fees is a critical disclosure. I just don't know if it needs to be done right up front in the first, before they even know what the case is about.
Right. And having read Amos's placement, and not that we're talking about informed consent here, but I wouldn't have a big opposition to moving it out of here and putting it later in our part of the written contract. I wonder, Kim, what do you think?
I mean, I was just trying to say if a person really wanted, I mean, how does a person know when they first go to an attorney that how much the fees are? Is it not until you get all the way down the line, you know, to explain your case, then you kind of more know? If that's the case, then I'm okay pulling it from here. I didn't know kind of how that's set up, or if it could even be, that's why I was like, is there like a cost sheet that a person could do? I leave that more to the experts, but if there isn't something that they would know right up front, they have to get more information, then I'm okay moving it just onto the written consent.
I agree. I think there's a source of stress, the not knowing. So if there's a general statement, it may calm a lot of the nervousness and anxiety, and if we're caring about that. So for that reason, now I'm remembering that I liked it where it is, but if the majority think it should be moved to later on, that's fine.
I agree that it should be here in the first disclosure, but I think it should be something pretty simple, like the method of billing. I don't think that's needed, but here, there's like 2 or 3 pieces of information it would be helpful to know right in the beginning. What's the hourly rate, if there is an hourly rate? And what's the percentage, if it's a percentage fee? Are we allowing that? I don't remember. And also, if there's some, like it says price list, cost sheet, if there's some fixed amounts that the paraprofessional is going to charge, could put those there too. I don't think the billing method and other stuff is needed.
I think what you just said is the billing method. The reason I did it that way is because
No,
we
it's
really
not.
started not having a fee cap or impose any kind of fee structure. So some paraprofessionals may have a flat fee for certain services. Some may only charge hourly because they don't agree with flat fees. Hard to figure out. So that was my reasoning behind having that. So just in general, what is your fee structure? Where if we limit it to hourly, maybe some paraprofessional doesn't have an hourly fee, or percentage that only is going to apply to, I believe the way we're talking is enforcement of judgment. So I think it needs to be more general than price list, cost sheet. They may not have one.
To respond to Kim's question from earlier, so attorneys are only required to include it in a written agreement if it's a contingency fee. This is under the State Bar Act, or if they contemplate the legal services are going to exceed $1,000. What I'll just slide down here, because what I think incorporated in the written fee agreement was language from the State Bar Act. And the way the State Bar Act phrases it, that the written agreement needs to include any basis for compensation, including but not limited to hourly rates, statutory fees, or flat fees, or other standard rates, fees, costs, and charges applicable to the matter. But that, again, is when you know more about what the matter is. So if what we're trying to disclose here is just, this is how I usually approach these types of matters, but we need to get more information. We probably need to have something that's a little bit more generalized, like Fariba has suggested, I think.
And I'm okay with Fariba's if we decide to put something in here at this juncture.
Amos, what is your feeling on this?
Yeah, so am I. Again, as long as it doesn't undermine, the disclosures once they know what the case is,
Right,
and what they know what the proposed fee is, and that's clearly disclosed, I'm fine with this too.
What do we think about this? If we're saying that there is a fee cap, and there may be, there's a fee cap on contingency fees potentially. This may not be true if they're charging a contingency fee.
Yeah.
Maybe take that off here and then put it in the written agreement, because by that time they know if it's enforcement of judgment or
Right.
is,
The other thing is, I think the fees should be set not just by the paraprofessional, but it should be by mutual agreement with the client. Right. So,
Greg, could I interrupt for just a second? I need to leave. I wasn't planning on staying for the whole meeting. If it's okay with you and Justice Petro, what I'd like to do is respond to the points in your email, send that email to you, and ask you to distribute it to the committee. If that's okay with you and Justice Petro.
that's fine.
Yeah, it's fine with me as well.
All right. Thank you. I hope everyone has a good weekend.
You too.
All right. Bye.
So are the subcommittee is fine with this language here for the initial disclosure?
Yes.
Okay. Malpractice insurance. The first item is Fariba's language. The second really is taking the language for Rule 1.4.2 that applies to lawyers, which is if in this case a licensed paraprofessional knows or reasonably should know. It may bear some explanation as to why it's knows or reasonably should know. There are times where lawyers don't know that their coverage has lapsed necessarily. So there may be instances in which they say they have malpractice insurance, and then they find out, oh my gosh, I missed a premium and I don't. In that case, as soon as they find out that they do, this is why it's an ongoing obligation to disclose. They must disclose the absence of professional liability insurance as soon as they do know. But the idea was we were not going to penalize somebody if they reasonably thought that they had coverage, or perhaps it may not just be because they blew a premium payment. It may be something where the malpractice carrier decides to rescind coverage for whatever reason. So that they don't have professional liability insurance. A statement, hold what is it? Oh yeah, that they don't have it. And then this again is an ongoing obligation, but right now we're just talking about the initial disclosure. So it's in one point in time.
I see. Thank you so much for that explanation. So there is no requirement for attorneys to say, hey, I have malpractice insurance. I only put that there again from just the standpoint of information and providing peace of mind to the client. And if that's a decision-making point for them, it makes or breaks the deal, that they have a bond, they have malpractice, then I think malpractice insurance, I think it should be to disclose at the outset in this notice.
Yeah, and I think I had that in mind as well. I agree with Fariba.
What does yours say? Yours says does or does not. Oh yeah. Okay. So that actually is both you and, sorry, I had to put this together quickly. And Amos are both. Kim, are you okay with their?
Yeah, definitely. Just as long as they tell them, that was my biggest thing.
What
I
do
just
you
was
all think of
copying.
the- I'm sorry.
Sorry, I think I was copying from what was there previously when I had mine. So this really is, I think, language that was there prior.
What do you all think of the of mirroring the language of knows or reasonably should know that they carry, so that it's parallel?
We're going to repeat this again in the written contract, right?
I believe so.
So would it be okay to keep this one simple and then copy the language in the written agreement?
The only, again, the reason knows or reasonably should know is because it's a disciplinary standard. So you're essentially imposing a much higher burden on licensed paraprofessionals than is imposed on lawyers if they are reasonably incorrect about that information.
I see. Okay, got it. Thank you.
Well, I'm fine with the tracking the language, Greg.
Okay, the one other thing that I will point out is this is one disclosure that will not be standardized. So they're going to have to either circle does or does not, or something on the form.
The fees won't be standardized either, I assume.
That's right. That's right. So they're going to have, these are going to be areas where they're going to have to fill something in, which is fine because, you know, I think it still has more to do with information that the paraprofessional has before anyone walks in the door.
I have a comment about this paragraph. Oh, am I in the middle of something? Are you in the middle of something? I should shut up.
No, go ahead.
It occurred to me that, what do you think about putting something in here about the bond that is required?
I was going to mention
that. You
that.
read this and say, oh, no malpractice insurance, I'm completely unprotected, which wouldn't be true.
Yeah, I was going to, that's a good point, Ira. And it occurred to me when we were starting here, there is something in the written agreement about the bond in some of the members' versions, a statement confirming that the licensed paraprofessional is required to carry a surety bond as required by ad rule of court reference. And Fariba and Amos had suggested the name of the carrier and how to file a claim also be included in that disclosure, but that's in the written agreement, your versions of the written agreement rule. The question I think that Ira is raising, which I think is a good one, is why not include that also in the initial disclosure?
So I can say historically why we ended up where we are. Obviously, we can change our mind, but there was a policy decision made early on after hours and hours and hours of meetings about financial protection for consumers that if we weren't going to mandate malpractice insurance, we should have a disclosure that would inform consumers and incentivize paraprofessionals to get malpractice insurance, even if it wasn't required as a best practice, as an additional protection. So I'm concerned, I totally hear what you're saying, but I'm concerned that it really we don't want to say, I don't have malpractice, but it's no big deal. I don't have malpractice because you're protected anyway. We are trying to make sure the consumer is informed that there's no practice and incentivize the practitioner to get insurance.
What about saying something? a bond is less protection than insurance in a way. It's lesser in amount, almost certainly. What about saying something like, I do have a bond, but it is in this amount, and it's would be less than if I had insurance, something like that.
So I think that would be complicated because I don't think the comparison is so clear between, it's certainly not intuitive what the difference is between bonds and insurance, and we spent a lot of time on it. And the bond amount, face amount of the bond might sound like a lot of protection, even if it isn't.
Yeah.
Okay.
My opinion is not to add it, actually. I think that if they want to add that on as a discussion point when they're going through and explaining it, they can. But I think from what we should require them to put in there is whether they have or don't have malpractice insurance.
Okay.
It's better, you know, later on, then that holds them to it that, hey, you said you had a bond and everything, but I think here I don't see a need for it.
Okay.
My opinion.
I agree.
Oh, great, good. Okay, so the last element is something, Fariba, that you added, I think, to your version of the rule. I'm not sure if, yeah, that all disclosures that are required under this rule also need to appear in all advertisement, marketing materials, posted on their website and social media accounts, posted in their office in such a way that's clearly visible to all prospective clients. I have probably one point that I want to make on this. If it's a requirement for what needs to be in the advertisements, I think it should be in the advertising rule.
Okay.
Because I think
I
it's
was
very
expecting that.
confusing to put it in a different rule. And
And
we can
just-
cross-reference it if we want to do that in the advertising rule.
And just to be clear, Greg, on mine, I included this as well, except for the advertising, because I agree if we're regulating advertising, it should be in the 7 series rule.
Right, I see that. So you have in the website, social media accounts, and at the office. Do you see websites and social media accounts as being separate from advertising? Amos?
Some people's offices are their website and social media account, right? Some professionals.
I don't mind if you think it belongs, if it should be in rule 7 instead of here, if that's what you're saying.
I think so. I think what we would probably do is if it's in the advertisement, because advertisement is broadly defined under that rule, to not be more than just our traditional idea of what advertising means.
Okay.
What we could do to make sure that we're providing guideposts for paraprofessionals is use the commentary to make sure that we're cross-referencing, make sure that all this information is going to be required under rule 7.3 and put that comment under this particular rule so there's no confusion as to what their obligation is.
So can I ask, are we really thinking that all of this verbiage would be like in somebody's Twitter account?
Well, I don't think it could be on their Twitter account, could it?
No, or their Instagram.
I'm envisioning a link to something, you know how there are links to disclosures.
So a link back to the website with the disclosure.
Yeah.
And the reason I actually had written when I was doing notes for today, I liked Amos's language because I thought he was trying to leave off the advertising. I didn't know it was because of the other section, because to me an advertisement, there's no way you could have all of that information, as Leah was just saying. So I do think we're going to have to word it, Greg, to where it's like you have to have a link to your website or something like that with all of the information if we're going to keep this in here.
Okay. What I suggest is that maybe in our next meeting, just add to our list to revisit that advertising rule in light of what we decide here, and then we can make sure that it's consistent. Okay. We are at 12:09, so I just want to move on. I realized that this was going to take probably most of the meeting anyway, so we're, but I think it's important, and we've been able to make it through one of the rules. Let's move on to the written agreement. you all agree that with this language as being part of the rules, so I think we can move on to the required elements. Again, a statement that they're not a lawyer and that their license is limited. You all agree that this is has to be clear and conspicuous disclosure in the written agreement with all this other information about how it should be presented in the agreement. Scope of representation disclosure in the written agreement, you all agree to that language as well. And then you all agree with the fee language, which again mirrors the State Bar Act provision for lawyers. Kim, you included a note wondering whether a cost estimate should also be included in the written agreement.
I didn't know if that was something that would be available at that point in the discussion, to where you could kind of know, okay, this is going to cost me this amount of money. I was just taking that from our discussions on fees and everything. So I just didn't know in the practice itself if that would be something that would be available.
It is something I think that we previously had in the informed consent rule.
I can envision that this is going to be hard to do, as long as maybe we can make it conditional if possible or something, because for family law, my expertise, I can just envision it's going to be hard to do, right? Because the cost depends on how much the parties agree, what are the complications, have kids, but and some of them may not be quite possible to determine at the outset. But if, for example, the person is doing a UD answer and that's it, just the form, I mean, that's easier to have a cost estimate. So could we make it conditional by any chance? Or
well, I think estimate sort of implies that it's conditional somewhat, in my mind at least. But I don't know what the other subcommittee members think.
what do you mean? I'm sorry, what?
Well, a cost estimate isn't, you're not saying that necessarily is what the cost is going to be.
Oh, no,
It's
if
conditional
possible.
based on, changes in the scope of representation. It may in some instances be less than what you estimate.
But I don't want to mandate a cost estimate, only if possible. So there'll be situations that they can't even give a cost estimate.
If we want to say only if possible, then it probably should not belong in a disciplinary.
Okay, I just wanted to please everybody.
I mean, we can add a note that said the notes are really where we talk about, we provide interpretive guidance. We also try to avoid best practice language in our commentary in California, but that's maybe something that is a subject of a ethics opinion at some point. But
so again, sorry if this is repeat, but I think very strongly a cost estimate should be required as a minimum standard. I just think it should be separated along with the alternative and risks when informed consent is obtained.
I think it's
sorry,
burden. Sorry.
Just to be clear on what Amos said, Amos, you don't believe a cost estimate should be part of the written agreement?
So again, I don't mind if it's here. I think it should be definitely provided prior to the engagement. I just had it in a separate writing. So if in the conception that it's combined, it should be here, but my draft rule had it separated.
Okay. It seems, at least in my mind, it seems strange to not have the cost estimate in the written agreement, but regardless of whether there's a separate informed consent or not.
So that's why I'm raising it now, because I'm fine with this. And my deletion doesn't mean I don't think it's an important disclosure. I just had it elsewhere.
Is that imposed on attorneys right now?
No, what's imposed on attorneys is exactly what you see here.
Okay.
This is a State Bar Act requirement.
So
and again, it's not a disciplinary standard. It's attorneys are not disciplined for failing to include this, and it means that their contract may be voidable, and they're going to have to try to recover fees on a quantum merit action.
I'm curious, why do you think, I thought I just heard you say that it's strange not to have a cost estimate or something to that?
I think in best practices, a lot of attorneys may include a cost estimate, especially if it's a flat fee.
Yeah.
We'll include an estimate of what the cost may be. But it's because it's an estimate, there may be circumstances in which the scope of representation changes in a material way that changes the eventual total cost of representation.
I don't know. I just think it imposes an undue burden on paraprofessionals.
Okay, Kim, what are your thoughts?
You know, under normal circumstances, I'm trying to keep them the same, but in this one, because the whole purpose, I think, is, you know, to bridge that gap, you kind of need to know what that cost estimate is to kind of look around. So I actually think that I would put it in here. If there's an estimate that could be given, and it sounds like there is under normal circumstances. I think Amos had a reasonable estimate of the total fees and costs of services provided by the licensed paraprofessional. I like that if we can add that in there, and if that's something, I don't want to put them in, you know, to Fariba's point, I don't want to put them in any you know, something they can't do, but it sounds like that's something that would be common.
I could put that here, but I just want to make sure, because Amos has made this point a couple times, that he has that under the informed consent. I could put that here for now, but I think, Amos, I'm going to challenge you for a second, that you would only want that here if for some reason the group decided not to recommend a informed consent, separate informed consent requirement.
Well, again, I don't mind if it's disclosed in two places. I think it's an important disclosure. My concern is that it doesn't get disclosed at all. That would be
okay. All right. That seems fine.
Greg, may I ask that we have a practicing paralegal LDA on the call. I'm just wondering if she thinks this is going to be possible for her, because again, I think it depends on the area of law, and we're imposing it on every paraprofessional with every specialty. And I don't know if she's still there, but I would be interested. Oh, if that's okay, Greg, I don't want to get us off the.
Fine with me. Do we want to? Who is that? Is Angela?
Elizabeth.
Hi,
Elizabeth. Oh, Elizabeth.
everyone.
Okay.
Thank you. So I'm not part of the working group subcommittee for this one, but I'm happy to give my comments. Fariba, can you ask the question again? Sorry. You're on mute. Sorry.
Greg, could you highlight the language
Sure.
that we're talking about, please?
Yeah. This language right here, Elizabeth, is what the group is considering whether to include as an element, a required element of a written agreement that a paraprofessional has to enter into with a client.
So you've already interviewed your client, you have agreed, the client has agreed to hire you, and this is your contract. Does this impose an undue hardship? Do you do family law right now? Okay.
Yeah.
As a family law paraprofessional, let's say, could you do this reasonably easy?
Yes. Right now, what the LDAs are doing, they either offer to say a flat fee. This is a flat fee that we estimate is going to take to finish your case from beginning to end. Or we say this is the hourly rate. And if we do an hourly rate, we give an estimate of the time of completion for what we think it's going to take. So in our contracts, after meeting with the self-represented litigant, we're able to more or less see what it is they need, how we can help, and we can give reasonable estimates.
Okay, and can you envision with all the added tasks that paraprofessionals will be authorized to do, is this still possible? Because right now you're quite limited, right? This is going to be expanded. Would you think that's still, your statement's still true, your opinion still same?
There are times where we plan for one plan of action, but we can't plan what the other side is going to do.
Right.
So there is a disclaimer that we put that says if additional services are needed, a new contract would need to be signed, so that we don't box ourselves in. And at that point, when they do decide that another service is, perhaps it's being referred out to an attorney, and the client is given a choice. Like, I've taken you as far as I can with our contract. You don't have to sign a new contract for new services. You can pivot at that point. If that helps.
Yeah,
Yes.
that does help.
Yes, and this is only an estimate, so thank you.
Are you comfortable with it, Fariba?
I'm more comfortable with it now.
All right. Let's move. Contact information in the agreement was a suggestion from Fariba.
Greg, real quick before you leave that point.
Sure.
I just had a very minor issue with regard to the concept or the term expenses in the Attorney Rules of Professional Conduct and also in the current draft of the Paraprofessional Rules of Professional Conduct. In one place, Rule 1.15, where you're enumerating what should go into your client trust account, an advance for cost is mentioned, but also an advance for expenses is mentioned. If you go to the rule that deals with payment of a client's personal or business expenses or costs, there's a definition of cost, and that definition of cost includes reasonable expenses. And so in two different places in the Rules of Professional Conduct, costs are folded into expenses or vice versa, but in another place, they're separately mentioned. And so I'm just wondering in this context, it would seem to me that you would want to mention both cost and expenses. If you're trying to give the consumer a reasonable estimate of these charges, then adding the word expenses there might make sense. And that would align it with Rule 1.15. The other rule has its a definition, but that definition is only for that rule, the payment of personal costs and expenses. So that's just a small technical point.
Thank you, Brandy.
Yeah, I agree with that too. Thank you.
Okay. Contact information. Kim, this is a suggestion from Fariba and Amos. Do you have any issue with having this?
No, not at all. Good with
Okay.
it.
And then I think everyone agrees on the duty to inform being included, duty and confidentiality, just a statement as to what that duty is. The right to terminate the agreement, the surety bond disclosure. Fariba and Amos added the name that they should include the name of the carrier and how to file a claim if necessary. You
I'm
okay with
good.
that, Kim? Okay. Malpractice insurance. Let's see. Okay. This is Amos's version and Fariba's version has or does not have, again. If they have, they must include the amount of the coverage. The one thing that I'm going to mention again is for lawyers, and we're not really capturing this yet in the rules, for lawyers, the duty to disclose the absence of professional liability insurance is ongoing. And right now in our rules, we have not included that ongoing obligation yet. We have it now in our mandatory disclosures, potentially in the written agreement, but we have a separate rule that says, even if you didn't have to disclose the fact that you didn't have malpractice insurance at the initiation of representation, if subsequently in the course of representation, you no longer have insurance, you need to make that disclosure as soon as it's practicable. So we may want to include that. I'm not sure it would belong here, but I just want to make a note of that.
I remember that seeing that somewhere in language. Is that somewhere else, Greg?
Well, normally I know, because of what we've done is we've essentially, for lack of a better word, hijacked rule 1.4.2, which is the rule that imposes that obligation on lawyers and turned it into a notice to consumer rule, because they were similar in the sense that they both involve disclosure obligations. But we may want to have yet another rule that makes it clear that this is an ongoing obligation. And it may be under that rule 1.4.2. It just would be another paragraph that I think similar to the formulation that we had before, to make clear that, hey, even if you said you had malpractice insurance, if later on down the road you lose it, you need to let them know.
I would agree with that.
Okay.
I do too. And Greg, if I remember correctly, the meeting where we had the speakers from bond companies, or whatever you call them, we talked about how even a bond, if they pay out a claim, the bond is for 3 years, I think. And if they pay out a claim, the paraprofessional cannot replenish it. The professional cannot replenish it, right? So the cover, if they pay out the whole thing, for example, it's $100,000, but let's say they paid out the whole thing, that paraprofessional cannot buy more, replenish the funds until the term of the bond is over. Do you remember that? Am I wrong?
So I could answer that. So, so it is true when you buy a bond, let's say $100,000 bond, That's the total amount that's covered. So any claims reduce the value, but you can pay to have it go back up. So you could replenish it, but if you don't pay extra,
Oh, okay.
it's just that, you just use it up until it's gone.
Okay, so the reason I brought that up is it kind of goes with the ongoing duty to inform. So if the paraprofessional doesn't pay to replenish, I wonder, I'm just putting that out there. Just remind.
Well, I think that's a good point. And I think, I mean, normally what I've been thinking about is that, if they no longer have a surety bond of $100,000 because there's been payouts and they either don't replenish the amount or the surety bond carrier will not allow them to carry a $100,000 bond, they no longer meet the requirements for licensure. So at that point, they essentially would be, to the extent that State Bar is notified of that, their license is administratively suspended until they can meet that obligation. So to the extent they continue to engage in the practice of law and represent clients, they are now engaging in UPL. But at the same time, I think there should be a disclosure obligation, is what I think what you're alluding to. If their surety bond amount falls below the required amount, they need to notify their clients that I no longer can represent you because I'm no longer in compliance with the surety bond requirement. So
I'd agree with that as long as you make a note to include that in the rules of court, because I don't think we've drafted or discussed that would be the result if they if they paid out a claim, if the bond company paid out a claim. The bar would know about that. They could be notified.
Right. Okay.
Do we need that in the surety bond area too? Because I don't think we have that over,
Yeah, that's why I say in the rules of court, because I think that stuff is going in the rules of court. Not in the
Okay.
professional conduct.
And that's me, I have to say, that's me interpreting, because I know that a requirement for licensure is you have to carry $100,000 surety bond. To the extent you're no longer carrying a $100,000 surety bond, now it's $80,000. You're no longer complying with those rules. And so, and yes, I do recall that the surety bond companies can notify the State Bar when that happens. That's a type of reportable event that, it's similar to when somebody doesn't comply with MCLE or they don't pay their annual fee, lawyers, they are administratively suspended until they can come into compliance.
But are we sure that how this works? Meaning, let's say there's a $20,000 payout. I still want to be able to continue to practice. Is it easy for me to bump it back up to 100,000? Like, do we know that? I would want to make sure we know that before we,
Yeah, there needs to be some thinking about how you can bring yourself back into compliance.
Okay, so why don't we, Linda or I can reach back out to the folks we talked to.
Yeah.
Okay.
I think what we just want to, for our purposes here, just make a note that that there should be also a disclosure requirement. If you are no longer in compliance with your surety bond requirement, that you're notifying your clients.
Okay.
As a disciplinary standard. Okay, so I think everyone agrees a statement about how to file a complaint with the State Bar should be included. A statement regarding the division of responsibilities. Everyone's in agreement on that. And then there's a catch-all board required disclosures, any disclosures that may be required by the paraprofessional board. So this gives the board a little bit more flexibility to respond, especially if there's new issues that come up that they want to require. We have similar rules like this when it comes to standards, like the client trust account rule allows the board to adopt certain standards for how client trust accounts are managed, and that those are incorporated into the disciplinary rules. Okay, let's move on to informed consent. So it seems like we have consensus on those first two rules. Now, informed consent, everyone agrees that there should be written informed consent. I think the difference is, one, Fariba and Kim are advocating for it to be included in the written agreement rule. Amos wants it as a standalone writing, and then Amos also has a number of required elements that he wants in the informed consent, which I think it might be helpful, first of all, to discuss whether or not it should be a separate writing, and see if there's any consensus on that. And then also talk about the talk about the required elements and to see whether or not Kim and Fariba, you agree with Amos that these required elements that he's suggesting should also be included in the informed consent, whether it's in the written agreement or it's a separate writing. Does that make sense? Okay. Okay, so the type of writing, clearly communicated, again, in the preferred language is the way, oh, I'm sorry, let's go back to, as Fariba and Kim, you have two slightly different variations on this informed consent requirement as part of the written agreement. Fariba is suggesting that there be a written acknowledgement that they understand that the licensed paraprofessional is not an attorney, that there may be alternatives for legal representation and services available to the client, and the client voluntarily and knowingly is entering into the contract to hire the paraprofessional. Kim, you have prospective clients informed consent that they understand the licensed paraprofessional is not an attorney, that they may need to seek an attorney if the needed services go beyond the scope of the licensed paraprofessional, and that there are other alternatives available. These are, I mean, I don't know if we want to discuss the differences between these and whether Fariba and Kim want to come to some consensus on that, or just move on to the more specific elements that Amos has included.
I kind of want to understand something at a higher level. And this is the difference between calling it an informed consent, which is a term of art, as I understand from our previous discussions.
It's a defined term.
Right?
And then the definition again, because that might be helpful.
Yes, that'd be great.
It is a defined term under the rules of professional conduct, both for lawyers and what we're.
Right.
Can you see right now, can you see the rules of professional conduct that I just pulled over?
Mm-hmm. I can.
Okay. All right. Let's go up to. Okay. Okay. So informed written consent mean the disclosures and consent required under E must be in writing. And E says that informed consent means a person's agreement to a proposed course of conduct after the licensed paraprofessional has communicated and explained, 1, the relevant circumstances, and 2, the material risks, including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. So as I think we've talked about before, this requires the paraprofessional or lawyer to obtain information that will allow them to make an assessment as to what the relevant circumstances are and what the actual and reasonably foreseeable adverse consequences might be to the course of conduct. The course of conduct in this instance is engaging the paraprofessional for legal services, right? So, so informed consent is not something that can happen in the first conversation without obtaining some additional information. And it needs to be tailored to the circumstances because it has to include the relevant circumstances.
And can I give a real world example? So, and this is, again, I think fundamentally why I think it needs to be a separate writing or has a very different purpose than the engagement agreement. If somebody comes to a paraprofessional and says, I'm being evicted, I have this very factual, I have a rent controlled apartment that I've been in for 30 years. I have really great facts and it's a pretext. Probably an attorney would do a jury demand and would take the case and may or may not settle and would take it all the way. What is the required disclosure when you take that, when a paraprofessional sees that? Is it, here's a form that says I'm not a lawyer, and buried in the written agreement for my fees, it says you acknowledge that you understand I'm not a lawyer and I can't do everything a lawyer can do. I think it needs to be a conversation that says, I can't, we can discuss whether we do a jury demand, but I can't do a jury trial in your case, and you might need a jury trial. This case, probably I can help you with the answer and find you an attorney, but there needs to be a informed consent. There needs to be information given to the potential client that makes them be able to decide if it makes sense to do this engagement in their circumstances. Same thing in consumer debt. If there's a debtor that has been harassed by a creditor, creditor harassment claims are not part of the program, or at least it's one of the exceptions. So it needs to be now that the paraprofessional knows what the case is, they need to inform the client what they can do and what they can't do. And, or at least it needs to be something that enough so that the proposed client can make an informed decision. That's the real, and I don't know that that's captured if you just say, you know, in the written agreement rule where you're talking about the terms of engagement, oh, and by the way, there's informed consent that they're not an attorney. I don't know that that's meaningful at all. Again, it's how it's enforced. So what I've suggested is some particular disclosures that are required probably need to be practice area specific, to say if somebody's coming in with a, you know, domestic violence that include children, this is what we discussed at the last meeting, you know, is it enough for the client to sign a written agreement that, you know, on page 3 says, and I've told you I'm not an attorney. I've told you that 3 times now. You understand that I'm not an attorney. You know, I don't know how helpful that is.
So again, I'm just trying to understand. I don't mind the separate writing. I mean, what I have a little bit of an issue is calling it informed consent. To me, it's getting the information to the client. Okay, getting clear information to the client, make sure the client has an understanding. Does it matter if we achieve it with a separate writing called acknowledgements, or do we have to call it informed consent? What is the benefit of having an informed consent? A document called informed consent versus just give them the same information and just make it a written acknowledgement.
So can I say that? Because again, I think there's been some really confusing discussion about this because Andrew raised some concern about whether the definition applies. I think there's no doubt that an informed consent requirement can apply prior to representation. In fact, I think it's mostly used in the context of conflicts and getting waivers of conflicts before you engage, you know, another client. So I don't think there's any issue there, but obviously we can talk more about that with ethics experts and get other people's feeling. But the difference between understanding the difference between a mandatory disclosure and an informed consent requirement, I think is essential. So a mandatory disclosure could be a standardized form. They take it out of the stack, they give the same thing to everyone, you're required to provide this disclosure. That's not the same as informed consent. Informed consent is making sure, given the specific circumstances, what they've learned from the client circumstances, they need to make sure the client understands the alternatives and risks in making a decision. So there is a fundamental, I'm not saying one is necessarily right or wrong, but there is a very big distinction between a mandatory disclosure and an informed consent requirement.
And I think it's impossible. You could have an informed consent and the client may still sign it, but it doesn't ensure that the client understood it, because the client could totally be glassy-eyed and go, oh, just tell me where to sign.
And the way that's actually assessed, just so you know, it has to be a reasonable person standard. So if somebody says at some point, challenges and says, hey, I know I signed this. First of all, if you sign something, there is an assumption that you read it and you understood it. but that can be overcome if it's actually not in compliance with the rules. So if it's not really providing you the relevant circumstances, because that's what's required, you need to disclose the relevant circumstances, or if it's somehow convoluted so it's not easily understood by a reasonable person, or you just botch the actual or reasonably foreseeable adverse consequences. So in Amos's example, if you fail to disclose to that person, hey, you may lose your rent control apartment because I can only take representation so far, and at some point you may have to represent yourself, and that may increase your likelihood of losing or something along those lines, then you have failed to provide informed consent. So that it's really going to be assessed on the back end once something adverse happens and the client challenges and says, I know they told me to sign this, but this consent really didn't meet the requirements of the rule, if that makes sense.
But I'd also like to...
disclosures are a little bit different in that we've just gone through the mandatory disclosure rule. It's very, very much like a menu. You need to include this, 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 and this. There may be some areas where you're customizing, but it's really not based on the client's circumstances. It's more based on your own circumstances. I have a price sheet, and these are my price sheet. This is my license. This is the limitations on my license. Informed consent is different in that I'm taking your facts, looking at them in the context of representing you in this matter, and then telling you, look, these are the relevant facts. And because of these relevant facts, including the fact that I'm limited in what I can do for you, and these are the things that you need, these are the actual or reasonably foreseeable adverse consequences. Do you agree to keep going forward with me representing you? And if something bad happens, you understood going in. So it's a bit different. Amos is absolutely correct. This is very different than the mandatory disclosures.
I'm thinking. Go ahead, Kim.
The other point that I would just make is, because I think it's important, Amos has made this a couple times, but I'm going to emphasize it for you, Amos, is that making it a separate writing calls it out. Okay, it makes it very clear to the, and this is part of the criticism with the malpractice insurance disclosure for lawyers. They're allowed to put that in the retention agreement, and a lot of clients don't even see it. It's not a separate writing requirement. So there are instances in which we require separate writing because we really want the clients to see it. Okay, so and if we want to make it a separate writing requirement, my only request to you would be make sure what's included in that separate writing is essential, essential to obtaining informed consent, and doesn't repeat a lot of the things that may not be necessary because it's already covered in the written agreement.
That's what I was just going to get to, because I'm kind of I'm understanding what Amos is saying. I think I'm concerned about putting too much onus on the paraprofessional to be very specific about what alternatives are available and all of that, but we could get to that. But then there's a lot of duplication between the disclosures, the written agreement, and this. And I'm wondering about, well, first I was sitting here thinking, well, maybe we scrap the disclosures. We just go with informed consent and the written agreement. But I do think there's something important about having some standardized language on a website, a sheet that I hand you, whatever, that just kind of outlines roughly who I am and what I can do. So I think there's some value in that. So I'm kind of getting to, well, maybe we need 3, but do we have to repeat like this thing? Like, I'm not a lawyer. We now have that in all 3 places.
Yeah, actually, that's a good point, Leah. Why don't we go through the required elements? Because I think it'd be helpful.
Okay.
And we could decide whether or not, based on where there's consensus, whether or not everyone agrees that it should be a separate writing or not.
Great. Can I just jump in real quick?
Sure.
Maybe that from my perspective, I'm with Leah now. I understand where Amos is coming from, in the fact that I do think it needs to be a separate document. I don't think there should be the duplication between the written agreement and the, whatever we call that second document, the agreement to, understand what I'm getting into. Because I think that agreement and the written agreement should cover, this is my case, this is all of this information. And that informed, I'm going to call it informed consent because it's easier. That informed consent, that document should really cover the issues that could happen because I'm using a limited licensed individual. I completely agree. I don't think there should be duplication. Where I'm going to struggle, and I'll probably dissent on a lot, is what's in that informed consent.
Right.
So that's where I do see, but I do still see the complete value of that notice to the consumer up front, the written agreement covering the case and what we're going to be doing, and then that second one that is separate, that I actually have to sit down and look like, hey, see this, I'm going through this with you, and you have to agree and sign it at the bottom. You have to sign both the written agreement and this one, but they're different. So that's kind of where I am right now.
I hear you. And as we go through these things, we may decide that certain things that we've already decided should be in the written agreement actually are better placed in the informed consent.
Right, and so I totally agree with that too, and that's why I was concerned about the order we were doing it, because it would be repetitive from if we do it this way. But I think we're all in the, well, I haven't heard Fariba yet. One thing I want to say to you, Fariba, about your comment is, because I think it's a fair one, about the enforceability of informed consent. But informed consent is a very well understood, defined term. It's used throughout the rules of professional conduct. This is not, we're not making up an extra, a new concept here. We're just saying that it's important that just like when a attorney takes on another client that might have a conflict, there's a rule that says they need to get informed consent before they can do that. And they need to explain the circumstances so the client can make an informed decision. And that's, I think, why I like the defined term. It's going to be enforced in the same way informed consent is enforced in all other discipline cases.
And I think I'm on the same page with everyone. Sorry, Randy. And I just have one more question. This informed consent requirement that we're considering, the same informed consent is not required of an attorney, right? I know there's several different provisions that require informed consent, like waiver of conflict, all that, but this particular type of informed consent, right?
This particular type is not required of attorneys, but there's probably a good reason for that because attorneys are not limited in what legal services they can provide. So,
but to be fair, we don't require attorneys to disclose other available choices. Like, and someone who is eligible for free legal services may go to an attorney. Attorney's not required to say, oh, you might not have to pay for my services. Check out free legal services first.
Mm-hmm.
They're not. So I think
we need to go through the elements.
Yeah.
I think that's the most important thing. I think actually we're making incredible progress right now as a group.
But I have one more question. Is
Sure.
it practical for every area of specialty? I know you've talked about UDs, evictions and rent control, but is it really practical?
I think it is because the whole idea of informed consent is it must be customized. And and that's one of the requirements. This is part of the training too, that we're going to have to do for these paraprofessionals. They're going to have to learn how to do informed consent as part of their training so that they know what to look for in their practice area and what they need to make sure that their clients are aware of and how it can lead to adverse consequences if they're not aware of it. So I think it's something it's reasonable because they are limited in what they can provide. But I think going through, rather than talking about it in this sort of 50,000 foot view, I think it's really important to go through the required elements. And we have about 13 minutes, so I know that we're going to probably spill over into the next meeting. But again, I'm actually pretty gratified that we are now starting to talk in a common language around some of these things. And I think if we go through the elements that Amos has provided and see if we have any consensus on what we think should be an informed consent from what he has or anything additional that you want to add. And then we can pick up the conversation next time, because this is probably the 3 most important rules that we're going to put forward. So I think it deserves even the time that we've put into it so far.
Yeah, and on that importance point, I do think this is like one of the fundamental consumer protections that we are adding by regulating this new license.
Yeah, I think all 3 rules are, quite frankly. So, okay, so and Leah just mentioned this. So one of the required elements, so first of all, I should probably put these in a different order because this was always the first one for everyone. I am not a lawyer. I think
Can I make just one quick comment?
Sure.
As I think this is the absolute correct methodology for your decision. And one thing that helps me when I think about 2 separate writings, a written fee agreement and a written disclosure for purposes of informed written consent, I think about the fact that the written fee agreement, essentially is just the contract. And so when you think about the contract, what's really required for a contract is just manifestation of mutual assent on the essential terms of the agreement, so that there's a meeting of the minds on what is the subject matter of the contract, what are the promises by both parties to the contract, so that they have an enforceable bargain. And that's very minimal in order to get a contract. And so if you're thinking about what should go into the written fee agreement, think about whether it is the meeting of the minds on the mutual terms of the actual representation. And then when you think about what might go into the informed written consent, everybody has said exactly what that is. And that is something that is very customized to 2 certain things. The essence of it is really the risk of harm to the client. And so that's typically not what goes into a contract, but it would go into an informed written consent, because you're agreeing to something that might be bad. And closely related in concept to informed written consent are concepts of waivers. And we're not doing a waiver, we're doing a informed written consent. That's a different. And so think about the client's agreement to something that could be bad for them, as opposed to what is just essential for having an enforceable representation agreement. That's the only thing I wanted to say that I hope will help.
I think it's a good reason why it makes sense to have them separated as well.
Yeah, I agree. And the first element, not a lawyer, to me really seems like an important thing to once again emphasize in an informed consent as opposed to the written agreement. Because that all the risks, that is the most relevant circumstance, and probably most of the risks flow from that fact in my mind, but I don't know.
Right, exactly. We need to further explain what that means by
right. Okay, and then alternative and material risks, available alternative and material risks, including any actual or reasonably foreseeable adverse consequences of proceeding with the engagement, which the material risks and actual and reasonably foreseeable adverse consequences really is in unison with the actual definition of what informed consent is.
So,
alternatives may
Greg,
not, but
Greg, just so you know, I'm fine taking that language out. I included that because there was concern about using the defined term, and that it include, and for me, it's just important that it's clear that it includes, risks and alternatives. But so I was afraid that we might not use a defined term, and I think it's better to use a defined term, but as long as the risks and alternatives are disclosed, that's the important part.
I'm sorry. So you're fine with taking this? This is the portion that essentially, I think, in some ways, parallels the definition of informed consent. Available alternatives, I think, is something a bit different because it's not necessarily disclosure of adverse consequences. It may be related to adverse consequences if perhaps you had a better alternative than going with the.
That's a fair point. So I would be comfortable using this language, of course, which is my proposal, or just limiting it to including available alternatives and material risks, and not needing the whole thing because that's in the definition of informed consent.
So
Get back to Kim's question of what the risks are.
Right, and I've been thinking about this a lot, and Amy, if you could give me an example of a risk, because when I'm thinking of this, I'm thinking of risks like if I don't file this by this time, or I don't do this, this is going to make the case fall apart, and this is what's going to happen. Is that the kind of risk? Because if that's the case, I do not believe they should be in here, because you have that in every profession, and an attorney doesn't have to do that. Because I've dealt with attorneys my entire state career, and I've had attorneys who are great and they do everything, and I have attorneys that aren't great and they don't. And so those risks, did they tell me the risks? No, they didn't, because I probably wouldn't have used, if I had a choice, I wouldn't have used them. So, that's where I'm coming from. If that's the kind of risks you're talking about, I don't think that they're meant for this document. If you're talking about a risk like you're going to use me, but I'm not going to be able to go forward in court and represent you there, that's something that I think should be in the informed consent. So that might help from my perspective with the discussion.
I totally agree with you. So the types of risks are related to not being a lawyer and having a limited license, not general risks that anyone has when they have a legal dispute. So what I propose here, this is just the definition, as I was explaining. This is just the definition of informed consent. As Greg mentioned, it adds available alternatives. So I'm fine with this, but I think we need to be helpful. I don't think we want to leave a naked rule that just says inform about the risk. I think we want to be much more specific, and again, give help to the paraprofessionals to the extent we can have standardized language or forms. Again, for practice areas, because certain things are excluded from the license. So, like my example of somebody who comes with a, two issues, one within the license and one without the license. They're going to need to explain, I can help you with this, but I can't help you with that. And you could, if you went to an attorney, they might be able to help you with both. I can only do one. I'll be cheaper, I'll be efficient, they can do their sales pitch, but they need to disclose that they have a limited license. And in their case, they're only going to be able to help them with, one thing. Same thing if it's, limited in the UD case example. It's very, very short time period between, the summons and complaint and the answer and then trial, not too long after that. And if they're going to need to hire an attorney to handle a trial, that's at least a possibility in many cases. Something's got to be disclosed up front. You can't just say, I'm not an attorney. It needs to be, in your case, you may want to make a jury demand, and I'm not going to be able to assist you with a jury trial. You're either going to be on your own or you're going to need to hire an attorney.
Amos, are you effectively getting at that? So let's say the not a lawyer bullet is expanded to clarify the limited in general, the limited scope, right? And then you've got customized disclosures based on type of license. So aren't you in both of those sections hitting the risks? The risks are my limited license generally, and with respect to the particular case type that you're asking me to help you with, here's what I can't do. So I'm wondering if we need that section at all, because we're addressing it in these other.
Yeah, no, I think it's the same thing as Greg started. I think all of the risks flow from not being a lawyer, but just saying I'm not a lawyer isn't sufficient. And now at this point in time, they know what the case is about. Hopefully they know what they can and they can't do, and they need to make sure the client is able to make an informed decision. So I agree with you, Leah, except it can't be a form. It can't just say, here's a form. I do family law. Here's a 5-page form about what's included and what's excluded. That's not sufficient.
No, I'm not saying it's a form. I'm just wondering if we need, I see Greg reworded it, but I'm wondering if it's already covered, if we have, I'm not a lawyer, and that's beefed up to explain what we're talking about.
And this is, let me just explain what I'm proposing here. First, I just took out the alternatives because we actually talk about alternatives here, so I don't think it needs to be twice. And it's a bit different than the material risks. If we say, again, I am not a lawyer, but now we're going beyond saying I'm not a lawyer. Now I know about your matter. So now I have to customize what that really means. So that means I need to disclose to you the relevant circumstance is I'm not a lawyer. Now we're getting into the actual and reasonably foreseeable adverse consequences of proceeding with an engagement with a non-lawyer in this matter.
I like this a lot because then this addresses the task this paraprofessional specifically cannot do. Like,
right. So if you envision, I'm going to help you with this divorce, but at a certain point, if you need to do a quadro, I can't do that, and it looks like you might need to actually have somebody do this because I don't know enough about the.
It forces the paraprofessional to issue spot in your example. So I can represent your divorce, but hey, I see you have a retirement plan. When it comes to it, I'm not going to be able to do that. I like this language, the way it's written.
Okay. And I don't know if we need for a lawyer, because I think that might be included in the material risk part.
Yep, I would agree.
I agree.
Yeah. So I don't. I think again that's sort of,
let's put it
theoretically it is included. Everything we're saying is included in the statement, I'm not a lawyer, but the disclosure to make sure it's an informed decision that's the consequence, that they may need to hire a lawyer.
And could that be maybe with you're not a lawyer? I'm not a lawyer, but you might need one. I mean, it can be separate, but it.
I don't. Again, I'm not so concerned about the order, though. But the point is, here's why you might need the lawyer, because there are certain things at issue in your case that I cannot handle. So I can handle this, but you might need to get a lawyer for that. That's the disclosure. I think just say I can, again, we just need to explain it. We just need.
Yeah. Okay. I get that. And what I just did was try to change this. So this may not be the actual language, but just to capture this idea. But we said potential need. Again, now we know now we know enough that there may not just be potential need, there's an actual need for a lawyer in some circumstances. And so you would say there may be a potential actual need to hire a lawyer for needed services that are beyond the scope of my license.
So just, sorry to be wordsmithing here, but not everyone can afford a lawyer. And part of the point is, this might be all people get, and they may be on their own. But again, I don't disagree with the concept. It would be best if they could get a lawyer for those parts of the cases. But I think the disclosure is, I'm not going to be able, you might need a lawyer, you might need to represent yourself.
Amos, are you saying that you think the word hire could be changed to a better word because it could have a chilling effect and undermine this disclosure? Maybe it should be potential need to obtain the services of a lawyer, because they might be pro bono services, they might be other types of way of getting the work
That
of
is
a
an
lawyer.
improvement, so that would be great. But I was just responding to the actual need language, because I just think it's, it's a potential, there might be a suggestion. If I were you, I'd get an attorney. I can't help you with this, and you'd be better off with an attorney. But bottom line is, they may not be able to afford an attorney.
We are now at 101, so I think we should pick up next time on just button this up, because I think we're moving towards some consensus on this, and then move on to the concept of alternative choices. But I think we did make some valuable progress today.
We did.
Yeah.
What I think the next meeting we had scheduled, also I had planned to have Brady present on all the other stuff that really OGC has been working on in terms of the other kind of statutory and rule changes needed to stand up the program. But I'm thinking that it just doesn't make sense. We're just not going to be able to get to that because we still have a number of things to do vis-a-vis the rules of professional conduct before the June 25th meeting.
Can I make a suggestion?
Yeah.
And this is something that we did with the Rules Revision Commission. We did a lot of work building consensus between meetings. And the way we did that is we've started to do that a bit here by sharing versions of the rule. But what the Rules Revision Commission did was it went a step further. Members who had received suggested rule changes from other members then provided email feedback to staff, like a spoken wheel. It goes to staff and then is disseminated out, so there's no meeting violation there. And we can hopefully, through email exchanges that are open to the public, try to build some consensus on this rule, and hopefully when we come back together, we could try to dispatch the remaining issues in 20 minutes.
So
I feel like we're very close at this point, actually, on coming to some consensus here. And on the other rule issues that I had on the agenda for today, they really are pretty discrete issues. And what I think I can do is just summarize what the rules are, what the issues are, perhaps even what my recommendation might be, and send those out and see if we can build some consensus on those. So hopefully we can move through those more quickly as well. Okay.
Then it sounds like you think we should go forward with the Brady work.
I think we need to.
Okay.
Well.
All right.
Okay. So on this particular rule, if Amos or Kim or Fariba, if you want to take a crack at revising the rule based on our conversation, or I can also just tee up what the remaining issues are with this particular rule, and then we can start building feedback on that.
Starting where we're just leaving off, right?
Yeah, just on the informed consent rule. So it seems like we have now moved towards, we're going to be recommending 3 rules.
Okay.
Would it be helpful, Greg, if we sent you, like, we think this should be in the written, we think this should be in the informed consent, basically from yours, just kind of, that's, I had started to do that while we're sitting here. Would that be helpful?
I think so. I think revisiting what we agreed to on the written agreement in light of the end of our meetings conversation, would be very helpful. No guidance.
I'm happy to do that, but just for Kim and Fariba, if you look back at what I did, that's the structure that I had. in mind when I put together my proposal.
Yeah, and I had looked at yours, Amos. I had said that basically when in our paragraph that Freeba and I had kind of put together, just use Amos's 1, 2, 3, and 6. So 4 and 6. So I think we're close.
Yeah, and I'm certainly flexible. That was sort of my first attempt.
Okay. All right. Thank you, everyone.
Thank you.
Thank you
Very
so
productive.
much.
Thank you.
Have a great weekend.
All right, bye.
Bye-bye.
Bye.